Good morning. I am going to just jump right in and get started. I have I think 8 positions on this calendar. Some may need more work than others, but we'll get through it this morning. I'm going to first start by just calling the calendar, figuring out who I have here, starting with position, and then I'll come back to each case and deal with the actual matters that are on. Atlantic 17th Residential versus Renee Holiday. Who do I have here on behalf of Atlantic 17th?
Morning, Your Honor. Craig Cooper on behalf of Atlantic 17th.
Hi, Mr. Cooper. And do I have anyone here on behalf of Ms. Holiday?
Yes, ma'am, I'm here.
Okay, thank you. And then I am going to move on to, do I have anyone here on the Sienna at Renaissance Condo versus Richard Tapp?
Good morning, Judge. Darius Reese on behalf of the plaintiff, and I just have one witness, Ms. Navika King.
Okay. Do I have anyone here? Is Mr. Tapp here? Do I have anyone here on his behalf? Mr. Reese, obviously I understand this is a default calendar, but has anyone with your firm or has anyone been in contact with Mr. Tapp or had any expectation that he might appear? I expect probably not since he was served by publication, but.
No, Your Honor. And then we did also send a notice out to the last known address that we have and still haven't heard contact.
Okay, thank you, Mr. Reese. JP Morgan Chase versus Jeremy Thomas. Do I have anyone here for JP Morgan Chase? Anyone here for JP Thomas? I'm sorry, Jeremy Thomas. Okay. Allison Derfler, I hope I pronounced that right, versus Brent Hurd.
Good morning, Your Honor. Rushal Chandra for the plaintiff, Allison.
Okay. And I see that Ms. Derfler is here. Do I have, Ms. Derfler, do you have counsel or someone here on her behalf?
I'm here on Allison Derfler's behalf.
I apologize. I totally thought you said defendant and I wrote it down that way. I'm sorry, Mr. Chandra. I apologize.
No worries.
Do I have anyone here on behalf of Brent Hurd?
No, Your Honor. Your Honor, Brent Hurd had signed a consent judgment and a settlement agreement and sent it to us this morning. I'd
Okay.
like to continue this for 30 days to file this in and make sure everything's up to par.
So typically what would happen if you've got a consent judgment is that it would be filed. And then I will close your case unless and until you need me to enforce that consent judgment in some manner. Is there some reason that you would need longer to do that?
No, Your Honor.
Okay. Then I will accept your announcement that the case is essentially resolved unless the court is called on to rule on the consent judgment or enforce some relief under the consent judgment, and just ask for you to file that in as soon as you can, perhaps today, tomorrow, and then
Absolutely.
like I said, we'll get the case resolved or we'll get it marked closed. And if you need the court to enforce it in some manner, then you can reach out and let us know.
Absolutely. Thank you, Your Honor.
Thank you, Mr. Chandra.
We may be excused.
Absolutely. Yes, sir.
All right. Thank you.
Belinda Sanders versus Damon Van Zant.
Good morning, Your Honor. Ashley Clement here on behalf of the plaintiffs, Belinda Sanders and their future husband enterprises.
Okay. And same question I've asked of several other attorneys. I obviously understand this is a default calendar, but have you been in contact with Mr. Van Zant or the corporate entity or had any expectation that they might appear today?
I did submit to them both by courier as well as by email or motion for default, and a breakdown as a cover letter explaining why we're here, and we haven't gotten a response. I will say though, I believe the order that the court had provided us said, nope, it says 9 a.m. Never mind, I'm sorry.
Okay. Thank you. And then next position, Palmetto Cove Community Association versus Tamu Colbreth.
Your Honor, Dan Wright for the plaintiff in this case. It's also a default case. We have not spoken with the defendant and don't expect the defendant to appear.
Okay, thank you, sir. Westfield Insurance versus a whole bunch of people.
Good morning, Your Honor.
Good
Galia
morning, Ms.
Scott
Scott.
for Westfield Insurance Company.
Um,
And
good morning. Yes.
good morning, Your Honor. Sarah McKim on behalf of Sovereign Cooper, Inc.
Good morning, Your Honor. Karen Gibson on behalf of C Solutions of Georgia, LLC.
Good morning, Your Honor. Kayla Rocker on behalf of Peterson Contractors, Inc.
Okay. Thank you all. Ms. McKim, did I write down correctly that you said you were representing Sovereign?
Yes, Your Honor.
Okay. So, I think my review, and it's a little messy because of the way things get filed in, not that that's y'all's fault, but it doesn't necessarily require when a stip gets filed to reflect that who the stip is for, except once you get into the document. And so it's a little messy. And I know there's also, which I very much applaud, some acknowledgments of service going on and that sort of thing. But here's what I'm running into, and there's a reason I'm addressing this before we get into the meat of it. I think by my review, Historic District Development entered into a stipulation that gave them until March the 6th to file an answer, but they've not done so yet. Sovereign, by my review, was served and had until January the 16th to, excuse me, they were served on January the 16th, and I don't see an answer or a stipulation in the file. And then Ethical waived service, and they had 60 days to answer. So I think they actually have until March the 20th, which is tomorrow. But I was kind of hoping to see those lawyers here today so I could make sure we're all on the same page. Ms. McKim, is there a stipulation or agreement or something in place that I'm not aware of relative to Sovereign?
So, Your Honor, my understanding, and I apologize, my firm was retained on Tuesday afternoon, so I'm trying to get up to
A
speed.
little bit behind the 8 ball. Yes, ma'am.
My understanding is that there was a verbal agreement between adjusters at Zurich and Attorney Scott regarding an extension through March the 4th. I do not, I have no knowledge of a stipulation that was filed.
Okay. Well, before we get into too much of the meat, because I'm going to come back for in a moment. I don't know if anyone is in touch with, because I am aware of the other litigation that's going on in front of Judge Glanville, which is, I understand the underlying litigation that Westfield is seeking a declaratory judgment here regarding any obligation it has to provide coverage or a defense. Does anyone know about, I guess, have about whether anyone is going to appear on behalf of Historic District Development or Ethical?
Do not, Your Honor.
Okay. Mr. Freehoff, can you look and make sure that we sent notices to those individuals and what the status is, and perhaps reach out to them while I'm dealing with some of these other cases? Thank you. Okay, I'm going to put you guys on hold for just a moment and come back to it. And then Bank of America versus Antoine Golden. Is anyone here on behalf of Bank of America?
Andrew Melhorn for Bank of America, Your Honor. Good morning.
Okay.
In this one, we don't have any contact with the defendant. We served him personally, but haven't been able to establish contact with him after some attempts. I don't expect him to show.
Okay. Mr. Melhorn, thank you for that very succinct recitation. I appreciate that. So we actually entered an order requiring you guys to file a default judgment motion, and we haven't seen it yet. I've reviewed the file, and I agree with your assessment that the defendant did not file an answer and that the defendant is in default such that that your client is likely entitled to a default judgment, but I don't have a motion.
Yes, Your Honor, and I do show in our system that we sent one. I don't have an envelope number, though, so I'm not sure if it actually reached you guys. Could I get till the end of the day to submit it? Would that be possible?
Yeah.
Okay, then
That's
I will do
fine.
that.
If you will sit tight, though, I do want to just run through the once I get to your case to make sure that we're on the same page in terms of the relevant dates, et cetera, and then I'll look for you to submit that proposed
Perfect, Your Honor.
an
Thank you.
actual motion and proposed order. Thank you, sir. Okay, I'm going back to the beginning now. Mr. Cooper, Atlantic 17th. So, and Ms. Holiday.
Yes, ma'am.
Mr. Cooper, you may have already figured this out, but when I was looking at this file last night, I mean, obviously we're the ones that reopened the case at your request. There had been a bankruptcy stay automatically that had attached. And then we lifted the stay and immediately ordered you guys to file a default motion. Although in retrospect, looking at it now, I question whether Ms. Holliday actually was in default at the time that we ordered you to file a default motion, depending on how you calculate and how the stay works. And I understand that the stay was lifted, excuse me, the bankruptcy stay was lifted sometime in January of this year. But the stay of this case actually wasn't lifted until February the 23rd. And now we have this unique situation where Ms. Holliday has filed an answer. Even by the most conservative counting, it is after the 30 days. If I count 14 days, she could have answered before the stay attached, and then 16 more days after the stay was lifted. The answer was still late, but still technically within that 15-day window, though no costs have been paid. I wonder, Mr. Cooper, have you been able to be in touch with Ms. Holliday and any discussion regarding the parties' abilities to work the case out, et cetera?
Yes, Your Honor. So we have been in touch recently. Miss Holliday, and correct me if I'm wrong. I believe it goes by Miss Pinson. Is that correct?
Sir.
Yes.
Okay.
The Miss Pinson and I have been in touch. I have an offer to. I made an offer to the board of the association, and we've not heard back from them on that. However, I don't anticipate the offer will be accepted without further discussion with my client. Their intention is to move forward in pursuing an order. I do have an argument in favor of the 46 days being passed at this time, and I believe that
I would welcome it, just in the sense that, as I said, I have not dealt with this particular issue in terms of whether the operative date that this court lifted the stay, or how the intervening of that automatic stay and then subsequent lifting of that stay, almost a year later, would affect it. So I would welcome the knowledge because it's not one that I've dealt with before, Mr. Cooper.
yes, earlier. So if I may, I guess run through the timeline. On this case was filed December 4th, 2024, and we're seeking a money judgment and order of foreclosure against the defendant. On February 12th, 2025, the defendant was personally served with a lawsuit. The affidavit was filed the day after. So we're starting the timeline on February the 12th. On February the 26th, 2025, the defendant filed Chapter 13 bankruptcy, effectively evoking the automatic stay under 11 USC 362A. On May the 28th, 2025, the defendant's first Chapter 13 case was dismissed. So from those up until now, I believe that 14 days have passed. I think you might have mentioned that, Your Honor.
Yeah, that's what I calculated between the suit and then her filing bankruptcy. I counted 14 days.
So it on the 28th, the defendant's first Chapter 13 case was dismissed.
28th of what day?
I'm sorry, May the 28th.
Okay, thank you.
From the 28th to June the 5th, at this point, we were not aware of the case at the time until much later on. So but I'm sorry, I take that back. In this case, we did not file a notice of stay with the court. And by the case being dismissed, the automatic stay of the federal bankruptcy court and USC 11 USC 362A automatically became ineffective. So an additional 7 days passed from May the 28th to June the 5th when the defendant filed a second Chapter 13 case. In that case, the automatic stay also goes into effect because it's the second case filed within the same 365 days. And in that case, the stay was extended by motion and order of the bankruptcy court. So at that point in time, 21 days had passed since the time the defendant was served. On January 7th, 2026, the debtor's second chapter, the defendant's second Chapter 13 case was dismissed. And it's at that point, Your Honor, that the automatic stay no longer becomes effective. We informed the court in this case that there was a stay in order to stay the proceedings of this case. But I don't believe that notice of the case filing in and of itself stayed the actual court case. In other words,
I all of the dates you're saying make sense. I don't have any reason to question them. I think the only complicating factor here is that although the automatic bankruptcy stay was going on and off, right, at various points in May, and then again fully ended in January of 26, the problem was this case was still stayed until February the 23rd. And that's entirely due to the court not processing your motion faster in terms of you filed it on January the 8th, and we didn't get it on file until about 45 days later. And so that is entirely at the feet of the court, but I also question how the court could find that those times, the defendant could have notified the court that the stay was no longer. But at the end of the day, if the case was stayed until the stay was lifted, did the defendant have an obligation to file an answer?
Well, I think, Rob, that the case was stayed up until the time that the bankruptcy case was dismissed. The notice that we filed, the notice of stay, is simply a formality, and we do that as a really to inform the court and inform the parties of the bankruptcy case. I don't believe that there's a formal stay of the Superior Court case, this case, because of that notice. I believe that as soon as the case was dismissed, the stay under 11 USC 362A was no longer in effect, and the time to answer began to run at that point.
Okay.
So there's no formal stay of the case. So we filed the additional motion to make the parties aware that the bankruptcy stay no longer stayed the Superior Court case, but I don't believe that there was ever a formal stay outside of the bankruptcy case.
Okay, thank you, Mr. Cooper. Yep. Ms. Pinson, you had raised your hand.
Yes, ma'am. So a couple things for me. I didn't know once the bankruptcy was out, I was supposed to answer. I had been emailing Sean at Nowak and Howard, trying to work something out. My goal at the end of the day is to get the unit sold and pay them, work this out. I tried to retain counsel, and they told me it was too short of a notice. I just want to do the right thing and work this out if we can, and get some time if I need to get an attorney or if we can work it out. I'm new to this, so I don't kind of know the dates and how to file and respond and all that stuff.
I understand that, Ms. Pinson. Unfortunately, the court is not supposed to treat someone who is not a lawyer any different than someone who is, for purposes of understanding the legal obligations here. And your case has some weird quirks to it. But at the end of the day, the argument that's being made by Mr. Cooper is that you were properly served on, let's see, I'm looking at my record. The affidavit of service was filed on the 13th, reflecting that you were served on February the 12th of 2025. And prior to filing bankruptcy, no answer was filed. And then after the bankruptcy stay was lifted, no answer was filed for about 2 months and 10 days. And the summons that you would have been served back in February says that you have to file something within 30 days. And so that's the conversation that I've been having with Mr. Cooper. Now, not for nothing, Mr. Cooper, whether Ms. Pinson is in the 15-day window or not, there is still, given the relative recency of the filing, a universe in which, the defendant could seek to set aside a default if all the procedural hurdles were satisfied. And that's a matter for Ms. Pinson to figure out if she can do. But the question for me today is whether or not to enter an actual default judgment. And so, I mean, I guess that's why, Mr. Cooper, I went back and asked, if you had an opportunity to talk with Ms. Pinson about whether the case could be resolved. I think, Mr. Pinson, what I would like is the motion that you filed on behalf of your client. It's sort of the standard default motion, which I totally understand. This is a high volume type of practice. But I had gone back and tried to count the days, and I think that if you are interested in the court granting a default judgment, that it would be helpful for the court to have that additional information in the form of a motion. And so what I'm going to do right now is say this, Ms. Pinson. It is my belief that there's no doubt that you are in technical default at least, right? I can't give you legal advice, but in Georgia, you are automatically in default if you do not file an answer within 30 days. And then there is a brief window in which you can open default if you do certain things before a default judgment is entered. As I said, it is my opinion from looking at the docket that there's no question that you are technically in default. The question is if you are outside that 15-day window, and Mr. Cooper argues that you are, such that even if you filed an answer, if you haven't done all of the things that are required under Georgia law, the answer, it does not count. And so what I am asking Mr. Cooper to do is file a motion for default judgment that provides me with some additional information. I understand there is a motion for default that was filed at the court's request on March the 11th. I think it, as I said, would be helpful to have some additional information. Also, that gives the parties time to perhaps negotiate any resolution that might be able to be had. And if that's something that you can do relatively quickly, Mr. Cooper, I can reset this matter for about 2 weeks from now, which is the week of April. It's actually the week of March 30th, 31st. The hearing date that I would reset it to would be either like Wednesday, April the 1st, Thursday, April the 2nd, or maybe even Friday, April the 3rd. That would give you time to file that motion for default, and we could have a hearing on that matter. Or y'all could announce to me that you have made some sort of resolution. What are your thoughts on that proposal, Mr. Cooper?
Yeah, sure, that'd be fine. And I intentionally didn't include any detail in this motion, kind of given the timing that I guess I was aware of this issue when the motion was filed, so I left it kind of vague.
Yeah.
But we also wanted to comply with the court's order to file a motion for default. I'd be happy to amend the motion if that's
Yes.
yeah.
And that's really what I'm looking for is just some amended information regarding that aspect of it, so that Ms. Pinson has some ability to review sort of the conversation that you and I are having about the relevant dates. And then again, that would also have the benefit of giving about a 2-week window so that the parties could perhaps discuss whether or not there is some resolution or agreement to be had.
Certainly. Yes, Your Honor. I'd be happy to do that.
Do you understand, Ms. Pinson, what I am advising the parties to do?
Yes, ma'am.
Okay. And so what will happen is we'll issue a new notice, and it will be for one of those days I mentioned, probably April 1st or 2nd. So about 2 weeks from now. In the interim, Mr. Cooper's firm is going to file an amended motion for default judgment, which has a little bit more information in it about the relevant dates. And then the parties can undertake whatever actions they believe are appropriate. And then the court will be prepared to go forward on that motion for default judgment in about 2 weeks, unless the parties tell me that there is some resolution that's been had. Okay.
Thank you, Your Honor.
Right, thank you.
Okay. Thank you both. Have a good day.
You do. May I be excused?
Yes, sir.
Thank you.
Okay, Mr. Reese. Sienna. So my review of the file indicates that Mr. Tapp was served by publication on December the 30th of 2025. And that the appropriate amount of time has passed the 60 days from the entry of the order, and that appropriate documentation was filed into the record regarding that publication. And so it appears to me that Sienna is entitled to a default judgment. My understanding is that Sienna is seeking attorney's fees, which would require some additional proof rather than any liquidated amounts that are in the complaint. And so if you would like to present that or call your witness for that aspect of your motion, please go ahead.
Thank you, Your Honor. And I did file exhibits A through C with the court. Ms. King, could you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Could you please state your name for the court?
Navika King.
And what is your relationship to the plaintiff in this case, Sienna Renaissance Park Condominium Association?
I'm the community manager.
And how long have you been the community manager for this association?
Since February of 2024.
And in your role, are you familiar with the books and records for the association?
Yes, I am.
Prior to this hearing, I provided you with two documents labeled Exhibits A and B. Can you tell the court in your own words what these respective documents are?
Sure. Exhibit A is the owner's transaction history. It spans from January of 2023 until present. Exhibit B is a summary from your office that includes the attorney's fees.
And are these true and accurate representations of the ledger and breakdown of the ledger you utilize in monitoring and determining the amounts due to the association?
Yes, they are.
At this time, Your Honor, I'd like to admit Exhibits A and B into evidence.
Okay, they're admitted.
Ms. King, are you familiar with the declaration governing the association recorded in the Fulton County Land Records?
Yes.
Pursuant to Article 5 of the declaration, does each record owner of a lot located within the association have an obligation to pay to the association assessments and charges levied by the association against their respective units?
Yes.
And pursuant to Article 5 of the declaration, if owners fail to pay to the association assessments and charges due, are they then liable to the association for all unpaid assessments and charges, which include late fees, interest, cost of collection, and reasonable attorney fees actually incurred?
Yes.
And in your role, are you familiar with the account histories and ledgers for each individual unit within the association?
Yes.
And are you familiar with the specific account history for the defendant in this case, Mr. Richard L. Tapp?
Yes, I am.
Is the defendant still the record owner of the subject property identified as 220 Renaissance Parkway, Unit 2312, Atlanta, Georgia, zip code 30308 in Fulton County?
Yes, he is.
And has the defendant paid all the assessments and charges levied against his respective unit?
No.
To date, how much in principal does the defendant owe to the association?
In principle, he owes $8,142.34.
And does the principal amount include purely delinquent assessments?
Yes.
Can you, I just want to direct your attention again to the ledger. Just take a few minutes to read over that and then just let me know when you're done.
The one from your office, Exhibit B?
Either one, Exhibit B
Okay.
or Exhibit A.
Sure. I'm ready.
Again, I just wanted to clarify, does the principal amount include purely delinquent assessments?
Does the principal amount?
Are there any charges for fines or late fees?
Yes, but they're separate, they're separated on this ledger.
And I think that's what he's asking you, ma'am. Yes.
Okay, and can you explain what the fines were for?
Yes, there were fines for parking fines. Also there's rules about having carts left in your unit for several days, and he was doing that as well. So that
And
was
so,
an issue.
and so your understanding, has these violations been cured yet?
Well, technically he has returned the cart, but no, he hasn't paid the fines associated with those offenses.
Okay. And to date, how much in interest does the defendant owe to the association?
Interest, $645.65.
And has the association actually incurred attorney fees for the work done on its behalf by Winter Capriola and Zinner?
Yes.
Your Honor, that completes my questions for the witness, unless the court has any additional questions.
No, thank you.
Okay, if I may, I can present my testimony for the attorney fees.
Yes, sir. Please go ahead.
And I did submit Exhibit C for the court's review, which is a copy of the attorney statement of account. It just documents all of the work that was done on the association's behalf by my firm. As an attorney duly licensed to practice law in the state of Georgia and associated with the law firm of Winter Capriola and Zinner, this testimony is to the attorney fees, expenses, and court costs incurred by the association. On behalf of the association, WCZ performed legal services for the association at a reduced hourly rate, ranging from the rate of $195 to $395. We do believe these rates are reasonable and customary for attorneys in and around the Atlanta metro Atlanta area, practicing community association law. In total, this firm spent approximately 15 hours in connection with this matter on behalf of the association, and the association actually incurred $4,702.44 in attorney fees, $331.62 in court costs. The association is entitled to recoup all such fees and expenses and costs pursuant to Article 5 of the Declaration, but also OCGA 44-5-60E.
Thank you, sir. Okay. Anything else, Mr. Reese?
Nothing further, Your Honor.
Okay. So, Mr. Reese, as I mentioned, my review of the docket does indicate that publication was proper, that it was done back in December, and that the defendant defaulted when no answer was filed on or before March the 2nd. More than 15 days have passed since then. And having heard the testimony of your client and your statements regarding your attorney's fees, it appears to me that your client is entitled to a final default judgment in the amount of $13,822.05. And a statutory lien in accordance with that in order to enforce it. And so what we will do is go ahead and get that final default judgment on file for your client. Anything else?
Nothing further, Your Honor. Thank you
Okay.
so much.
Thank you, Mr. Reese. Have a good day.
You as well.
Do I have anyone here for the JP Morgan Chase versus Jeremy Thomas matter? Okay. Belinda Sanders versus Damon Van Zant and Carib Life Media.
Morning again, Your Honor.
Good morning. So my review, let me find it real quick to make sure I am in the same. Let's see. So, so one thing I should let you know is my review of the docket indicates that y'all sent us a courtesy motion for default judgment and a proposed order, but your motion for default judgment actually has not been filed. I think my staff attorney was able to look in Georgia e-file and find that it had been left in as a draft, and so it hasn't actually been filed. Yeah, so I'm going to need somebody to go in and fix that before I can enter any relief on your on your client's behalf. I will tell you that my review of the docket indicates that Mr. Van Zant and Carib Life were both served on January the 24th. And that no answer, they defaulted when no answer was filed by February the 23rd. And I do see that Mr. Van Zant filed an answer on March the 3rd, but to date, no costs have been paid. And so that answer is not a valid, the court can't accept it because it is still in default, and court can't accept that court can't set aside default without the payment of costs. And no answer has been filed on behalf of Carib Life Media LLC. Did you, I don't know that I had, perhaps I did have a motion, I'm not sure, or excuse me, a proposed order, but I don't have any information regarding the amounts, liquidated or otherwise, that your client is seeking against these two defendants as part of a default judgment. Can you tell me what those are?
Yes, Your Honor. Also, just quickly, I'm not sure if you reviewed the docket yesterday or the day before. Our motion was filed the day before, rejected, and we refiled it yesterday, and it was entered. I had submitted or exhibits showing that it was entered 3/18 at 12:20 because of this issue.
Okay, I was looking at this. Let me look again. I was looking at this last night.
I can send you an email of it if you need
Nope.
it.
You're right. As I'm looking at the docket this morning, it does reflect that it is there. I was looking at it last night and it was not there.
No problem.
Okay. So please go ahead regarding the amounts that your client is seeking for final default judgment.
Our client had a demand in the amount of, I'm sorry, Your Honor, I'm pulling this up.
So are the amounts liquidated, or are you planning to present an affidavit or a witness?
They are liquidated.
Okay.
They are not liquidated, Your Honor. I'm so sorry.
Okay. Do you have a witness who's prepared to provide evidence regarding the amount of any default judgment you believe your client is entitled to?
I don't have a witness today. We were working to get the default judgment in time, and we're in the state of Florida. So we're trying to reach out to the client to get that witness. I was going to implore the court to see if we can schedule a second hearing for the second evidentiary hearing as it relates to the fees and costs entitled to the client and attorneys.
Okay. I used to practice in Florida. I know defaults there are uncommon and very different. But in Georgia, because default is an automatic statutory, it's a function of a statute. It occurs automatically. And then the question is whether it can be opened or not. And then the purpose of today's hearing was for an evidentiary presentation regarding the nature of the the nature and scope of any damages the court might grant as a default judgment. So as I said, the defendants are in default. The issue is going to be the amount of any judgment. I have another default hearing on March the 30th. Or I could probably squeeze you in on those other dates I mentioned earlier, April 1st or 2nd, which are all the same week.
I'll be prepared for March 30th, Your Honor.
Okay, well then we will reset your matter to March the 30th. And at that point, I will, I'm sure, have a proposed order in hand. And then you can be prepared to present any evidence that you will present on behalf of your client. Okay?
Yes, Your Honor. We did submit a proposed order, but is it, we're going to update the proposed order based on or
So
affidavit for attorney's fees?
I apologize if you, so I'm looking at this file, and it said, and I see that there was a motion for default judgment, which was apparently accepted this morning, and it reflects that it was filed yesterday. If you sent over a proposed order, I don't have it. It may be that my staff has it and I just haven't seen it, or maybe I have seen it, but there's a pretty high volume here.
I emailed it, sorry, Your Honor, I emailed it to Mr. Freehoff on the 17th.
Okay, well then I will take a look and make sure that I have it. And then I will look forward to hearing evidence from you on the 30th of March.
Thank you, Your Honor, and I
Thank you.
apologize.
No, that's fine. Have a good day.
Same to you. May I please be excused?
Yes, ma'am.
Thank you.
Palmetto Cove versus Tamu Culbreth. Mr. Wright.
Good morning, Your Honor.
Good morning,
Dan
sir.
Wright for the plaintiff. This is a default case as well. Obviously being on this calendar, but the suit was filed in this case December 18th, 2025. Defendant was served on January 22nd of 2026. Entry of service was filed January 29th of 2026, and we filed our motion for default judgment on March 17th of 2026. The damages in this case are liquidated. I'm here today to testify as to the attorney's fees on the case.
Yes, thank you. So yes, all the dates you've just recited are correct, and I do have them in your in the record. And so, I mean, it is clear that the defendant is in default and that more than 15 days has passed and no effort has been made to open default. So if you want to go ahead with your attorney's fees.
Thank you, Your Honor. My name is Dan Wright. I'm a lawyer. I've been a lawyer for over 25 years. That keeps going up, and I keep getting older and older. I've been licensed to practice in Georgia for 23 years. I'm a partner at Lazega and Johansson. Our general area of practice is community association, law, and collections litigation. I'm a partner in the litigation department, and our firm represents hundreds of community associations all across the state. Supervise other attorneys and paralegals doing the litigation and collections work at our firm. In this case, we represent Palmetto Cove Community Association. Our firm represents the plaintiff, and I've reviewed the attorney's fees charged on this case. My firm's attorney's fees, bills, and expense records for the case were marked as Exhibit A to my affidavit in support of our motion for summary judgment. The entries are there are entries in those documents for work done by me and or other attorneys or staff members at our firm, and I'm familiar with the entries on those bills. They were made at or near the time of the events they're intended to memorialize, and the entries on those bills are true and accurate to the best of my knowledge. It is the ordinary course of business at our firm for those entries to be made on the bills, and I'm an authorized custodian of the bills. Based on our records, the total amount of attorney's fees incurred by the association in this matter was $2,090, and the amount of litigation expenses incurred by the association is $799.74. Your Honor, I'm familiar with the rates charged by me and the individuals working on the case under my supervision. My hourly rate on the case is $350 per hour, unless otherwise noted. We do have some flat fee billable items that are on the bills. Based on my experience as a litigator, the rates that are charged are reasonable and customary for this type of work in the metro Atlanta area. And as lead counsel, it's my opinion that the work performed and the amount billed for that work was necessary and reasonable given the facts of the case. So therefore, Your Honor, I'd be asking the court to enter a judgment today, $4,125 principal, $199.38 in interest, $2,090 in attorney's fees, $799.74 in litigation expenses, and $218 in court costs, for a grand total of
$7,432.12. I think that's what's in your.
That is correct, Your Honor.
Okay.
We have submitted a proposed order with our motion.
I have reviewed it, and it does appear to be in order. And so the court will go ahead and enter that final default judgment in the amount that you have presented today. And it'll probably be on file for you later today.
Great. Thank you very much, Your Honor.
Thank you.
May I be excused?
Yes, sir. Have a good day.
You too.
Okay, I'm going to skip over Westfield Insurance for a moment and come to Mr. Melhorn for Bank of America. Do I have anyone here on behalf of Mr. Golden? don't expect that I do, but I'm going to give one more chance. No. Okay. Um, Mr. Melhorn,
Yes, Your Honor.
my record indicates that Mr. Golden was served on the 21st of January. And let's see, that service was proof of service was timely filed into the record. And so the defendant's answer would have been due on or before February the 26th, and there's no record that any answer has been filed. More than 15 days has passed since February the 26th. And so I believe that Bank of America is entitled to a default judgment. Is it a liquidated judgment, or are there unliquidated items, Mr. Melhorn?
It's a liquidated judgment, Your Honor.
What is the amount of that liquidated judgment that you are seeking?
It is $17,193.47.
And is
And
that
we are
entirely the outstanding principal balance of that credit card or credit account?
correct, Your Honor.
Okay.
And we're seeking costs on this as well.
Okay, and what are those costs?
I believe they're $300.02.
And those are costs associated with filing and attempted service,
Correct, Your Honor.
or I guess accomplished service. Okay.
Yes.
And is that the entirety of the amount that's being sought?
Yes, it is, Your Honor.
Okay. Okay. So Mr. Melhorn, as I mentioned, it does appear to me that Mr. Golden is in default and that your client is entitled to a default judgment in that principal amount plus court costs. If you can send me a proposed order, I can go ahead and get that on file for you probably later today. I just need that proposed order from you. I don't actually have a motion, so you'll need to get that filed into the record as well.
Okay.
And so once you file that motion, then we will go ahead and get the order on file for you. Okay.
Sounds great, Your Honor. I will do that as soon as possible.
Thank you, Mr. Melhorn. Have a good day.
You too. Thank you. Bye.
Thank you. Ms. Walker, you are a recent arrival. Can you tell me
Yes.
which matter you are here regarding?
Yes. Sorry, apologize for the tardiness.
That's okay.
It's JP Morgan Chase Bank versus Jeremy Thomas.
Yes. So I have a proposed order from you. I've reviewed
Yes.
the file. It does appear that your client is entitled to a default judgment, but I don't actually have a motion in the file. There was not. I
On
don't
the
know if
doc.
maybe this is one that got hung up in the system.
Yeah.
If you hadn't filed one at all, but I don't actually have one.
Yeah, I believe my legal assistant manually filed it because it was hung up in the system. So it should be on a docket. I just checked. I saw it on a docket, but my eyes are bad, so let me double check.
It is not. I'm
It
looking
is
at
not.
the docket.
Okay.
There is no motion
So
there. There's an
we can
affidavit of military service. There's another affidavit, which is probably attorney's fees or
same.
something, but there is no motion.
No motion. Okay, well, we can get that filed after this call, to be honest.
Okay, thank you, Ms. Walker. So as I said, I did review the docket, and it does appear that Mr. Thomas was served on January the 10th. Now that proof of that service wasn't filed until the 22nd, so the operative date is January the 22nd. But that Mr. Thomas became in default when he didn't file an answer by February the 23rd. And more than 15 days has passed since then. And so as a function of that, I do believe that your client is entitled to a default judgment. Is it a liquidated default judgment, or are you seeking any additional recovery?
Liquidated.
And what is that amount?
That's $5,433.17.
Okay. And I believe that I had already, as I said, we had this weird situation where I had a proposed order from you that I had adjusted and have already approved in that amount. I just don't have a motion. So once I have that motion, I can finalize your order for you.
Will do. Okay, well, definitely. Because we were like, we have to email it. It says to email the proposed order, but then forgot the docket part. So
Understood.
we'll get that filed immediately. But
Okay.
thank you for taking
Thank you, Ms.
this.
Walker. I appreciate it.
Thank you guys. Have a good day.
You too.
Bye.
Okay. Council, I think we are down now to Westfield Insurance, and I am typically fairly aggressive about defaults, as you might have gathered from this calendar. But I do I am aware of the ongoing litigation in the other case. I am aware that there seem to be some agreements amongst parties that perhaps is not reflected in the docket. And so I'm hesitant to take action in this case on a declaratory judgment just yet under the circumstances. Ms. Scott. So let's start with Ms. McKim, who I believe represents Sovereign. She indicated that she believed there was some sort of informal agreement for her client to file a response at some later date. Although I think the date I heard is still a date that is passed. So I'm not really sure. Ms. Scott, you're muted.
Thank you. So as we said in the motion, around February 7th, 6th, 18th, when the original answer was due from Sovereign, a representative of Zurich Insurance Company contacted me and said that they were an insurer for Sovereign, and they were trying to figure out what they were going to do in terms of an answer, and they'd asked for an additional 2 weeks. I consulted with my client. We granted 2 weeks, which would have taken them to March 4th. I provided, as I did with other parties asking for more time, I provided a prepared stipulation. I didn't receive a stipulation back, and I didn't receive a response back. And of course, we didn't receive an answer. And then Miss McKim called me yesterday and advised that she is representing Sovereign. So if, the time for that extended deadline has passed. And as I explained to Miss McKim, if they were to open default and in the safe harbor period, that answer would be due today.
Right. And I think that historic district development is likely in the same position.
Historic district development has an extension. They did not meet that extension.
Right. They had a formal stipulation filed, but it was for an answer by March the 6th.
6th. I spoke to that counsel, who is Jennifer Adair from Freeman Mathis. She told me earlier this week that she intends to open default by their deadline, which is Sunday or Monday, which would be Monday, the 20th. It'd be, Monday. So I suppose that's what they're going to do. She's not here today. I suppose that's what they're going to do. Now, ethical property is definitely a default. They have not asked for an extension. I have not heard from them. Their time to open default is over.
Yeah. So, I agree with you. Historic district probably has until the 23rd to open default. And I think that here's what I'm struggling with. Go back a moment. The one that you said is definitely in default. Is it Sovereign? Or is it?
It's ethical property.
So that's why I'm confused, because in the old days, because I'm old enough to remember the old days, right? There was that 9/10/72 acknowledgement of service where you had to answer in like 10 days. And then we all sort of migrated to this more 9/11/4 model. But the 9/11/4 model gives you 60 days to answer from some weird date that often is not documented in the file or documented in the acknowledgement of service. And so Ethical waived service on January the 20th. Now, the 9/11/4 says they get 60 days from when they were asked to waive service, which is a ridiculous date because I don't actually know that, and it is often not reflected in the waiver that is signed, but nothing is reflected in the waiver that is signed. Other than we agree that we agree to accept service or acknowledge service, and we've waived any defenses regarding. And so the reason that matters to me is that strictly construing 911-4 for waiver and acknowledgement, I don't know when you serve. I don't know when you sent them that request to acknowledge service. But if I were to give them every benefit of the doubt and they signed it on the 20th, is there an argument that they have until tomorrow to file an answer? That's what I can't figure out. And here's the issue. That may not have been your intention. Your intention, and I've seen lawyers do it when they file a waiver, is that you're going to answer in 30 days based on today being the date of service. But if it's not reflected in the waiver, then it's unclear to the court and potentially to the party what date by which they have to actually file an answer.
Yeah, they contacted me, but so I don't. I know that the 60 days was not discussed or
right, and probably not intended. That's just what the statute says.
Yes, you're right.
I know when I was
understand.
practicing, if I waived service, I just pretended like that was the date of service and we were going to answer within 30 days, right? But again, the statutory language of 911-4 is a little different. Here's what I think I'm inclined to do. It sounds, and whether it's fair or not, these are all experienced attorneys who practice in this arena frequently. And so, like I said, fair or not, I'm kind of inclined to give everybody the benefit of the doubt here. Not to mention the fact, Ms. Scott, that it seems to me quite clear that you have been highly professional in terms of trying to make sure you get service on people and, accommodating professional allowances for people when they say, can I have a stipulation, et cetera. So I don't want to hold that against you. But I also feel like there is, even if the 15-day window passes, there is a universe, if everyone were to file answers in the next, very immediate sense, that if they file appropriate documentation and move to open default, the argument really is going to be one of prejudice. And it would be assuming that all those fun little procedural T's and I's are crossed and dotted. So here's what I think I might do. I think I'm going to put a pause on this and reset this hearing for sometime that week that I'm talking about, March the 30th, April the 1st, April the 2nd, whatever everybody's pleasure is. I'm going to notice every single lawyer, even I don't think Historic District has actually formally appeared in this case because they've not answered. And the stipulation, I think you might have filed it, Ms. Scott.
Yes.
Right. And so now Ethical did sign a waiver, so they're in, and Ms. McKim is in the process of appearing on behalf of Sovereign. I think what I might do, unless you have strong objection, Ms. Scott, and I'll hear from you if you do, is move this entire matter, issue a new notice of hearing for everyone, and see if everybody is all on the same page by March the 30th.
Your Honor, I totally agree with that. I think, we're certainly, as you said, trying to be fair. We don't want to, short shrift the law or in any way, or anybody's rights. So I think that's perfectly fine.
Okay.
My availability is a little bit limited. I'm having surgery on the 1st.
Oh, goodness. Okay.
So March 30th would be better for me.
Okay.
And it's pretty significant surgery, so April 2nd wouldn't work either.
Okay.
But that's just my preference, and if it works out for the court and everybody else that's fine.
Well, given that you are the one who is graciously foregoing an opportunity to sort of aggressively try to pursue a default judgment here, I'm happy to accommodate your schedule, Ms. Scott. And so what I will do is renotice this hearing, and as I said, issue a notice to everyone. I believe that a couple of the stipulations that were filed do in fact reflect an email address for every single attorney that's involved in this case. And so we will issue a notice that includes those individuals. and make sure that we have all the players on that March 30th. And we will hopefully at that point, everybody will be back on the same page and we can just, move on from that. And, but I do think that historic district, sovereign, and ethical need to figure out if they're in default, and if they are, what posture they are in and what efforts they need to take to assure the opening of default, and or the setting aside of any technical defaults. I'm declining to issue a default judgment today as to any of them, but I reserve the right to do so on March the 30th if those matters have not been addressed. Mr. Freehoff, did you have something?
I did, Judge. I heard Ms. Scott say that she's been in contact with the attorney for ethical. Is that correct?
Yeah,
Been
he
in
signed a waiver.
Okay.
Yes, I haven't been in contact with him since then,
Right.
but I've been in contact with the counsel for HDDC.
Right.
Okay.
And I think the reason Mr. Freehoff was asking is I think our records indicate that a notice went out that did include counsel for ethical,
Yeah.
and that multiple people at Conway Ader opened that notice, but maybe didn't float upward to the attorney that needed to appear. Anyway, as I said, fair or not, I'm inclined to give these attorneys, these parties, the same professional consideration, Ms. Scott, that you have demonstrated. So I am going to enter, like I said, I'm going to reset this matter for March the 30th. And then, as I said, I do reserve the right to enter default judgments against those parties that are in default at that time if no appropriate efforts have been made to set aside or open default, depending on the posture that those individual defendants are in. Okay.
Your Honor, do you require an amended motion?
I don't. You've moved for default judgment. Any order that I enter is going to have some additional information in it about the dates and times and that sort of thing. And we can add that just as easily as you can. So.
Right. Thank you very much.
Any questions for me, Ms. McKim? Or I know I've got Mr. Hill, Ms. Rocker, and Ms. Gibson, who I think are just observing on behalf of their clients who are not in default or in danger of default. Ms. McKim?
No, Your Honor, I don't believe so. I think the court's instructions are, we need to figure out for ourselves what we need to do and go forward. So we'll do that. Thank you.
Excellent. Well, I will see everyone on March the 30th, and we will get a new notice out probably today. So everybody's clear on that. Okay.
All right. Thank you very much.
Thank you all. Have a good day.